law developments since 2008. The NLRB has acted only 2 of the 5 members. There's been some huge fights about whether or not that's even lawful for that to happen. President Obama has put a number of different nominees up. There have been huge fights over them, particularly with a gentleman named Becker, who has written some things that would shock most employers about what he believes. He believes employers should not be able to participate in the unionization efforts, and that unionization is something between the employees and the National Labor Relations Board. So for any of y'all who have ever fought against the union organizing, imagine you had that same fight but you couldn't participate in it. Odds are you're not going to win that. So that's something to keep in mind. Also, and I know this is something you've probably heard from everyone on earth, something called the Employee Free Choice Act. Who knows what's going to happen with that? For those of you all who don't know what the Employee Free Choice Act is, it's something that the unions have been pressing Democrats in Congress to pass. It would do a couple of different things. The number one thing it would do is it would allow what is called card check, meaning you no longer would have a private election. Instead, everyone, if 50+% of folks out there signed a union card, all of a sudden there would be a union in place. The other thing that it's going to possibly put in place is if the union and the employer are unable to reach a collective bargaining agreement and determine what the terms and conditions are going to be, that an arbitrator would be appointed to determine what the work conditions are. So imagine for a second that an arbitrator is put into place to tell you what your relationship is with your employees going forward. I will tell you personally, I think that's unconstitutional, but I'm not so sure it won't go into place nonetheless. So again, if I'm going to read the tea leaves, I think that the unions are, without a doubt, one of the highest contributors to Democrats. I think they contributed over $300 million to their campaign coffers in 2008. Democrats are, common sense dictates that they're going to want to repay that favor. They will probably pass EFCA, or the Employee Free Choice Act, in some version. What I think probably will happen is they will change election times. In the past, you've had 42 days to engage in a campaign. They will probably knock that down to 2 weeks or 7 days, which is how they do it in Canada right now. That means if you're not interested in having a union running around your organization and being the party you then have to negotiate with, I highly recommend you all implement some union avoidance training for your managers as soon as possible. And if that's something you're interested in, certainly reach out to me and we can discuss it. Some executive orders passed by President Obama. He signed 3 executive orders affecting rights of federal contractors and employees. Well, actually, there was another one even passed recently regarding folks that have federal contracts. And that provision, it said basically, if you have certain size government contracts, you're going to have to pay people, in essence, a prevailing wage or a wage they would have if they were in a union. So President Obama is, and again, this is not a political statement, but he's making it more expensive for employers to operate. They reversed several Bush policies that unions claim favored employers over unions. Another executive order was the notification of employee rights under federal labor law. In essence, they want you to begin posting notices telling people they have a right to join a union. That, in essence, is a blinking red light of, hey, you might want to form a union. Again, I don't begrudge President Obama for this. I will tell you, though, that, again, there are going to be a number of pro-employee provisions out there that are not going to be friendly to employers that aren't interested in being unionized. The economy and government contracting, again, this deals with folks who have government contracts, and it talks about the terms and conditions of collective bargaining. Another executive order is the non-displacement of qualified workers under service contracts. Requires contractors at federal buildings to offer jobs to qualified current employees when contract change. In other words, when the administrations change, successors must hire predecessors' employees. So that's obviously a big problem if you're taking over. You're going to have to bring the union with you. Pending labor-related legislation, we talked about the Employee Free Choice Act before. the bottom line is it's going to make it far easier for unions to organize, and there are going to be some major changes to first contract negotiations with the union. And first contracts are typically the most difficult ones to deal with. The Truth in Employment Act of 2009. This will amend the National Labor Relations Act to protect employers who refuse to hire salts for being accused of an unfair labor practice. For those of you all who don't know what a salt is in essence a fake applicant. It's somebody who really has no real interest in working for you other than to get in there, get the camel's nose under the tent, and start organizing a union. So in essence, it would make provisions about whether or not to hire salts probably going to be difficult to do. Rewarding Achievement and Incentivizing Successful Employees Act. That's a mouthful, and you can probably imagine that's not pro-employer either. It amends the National Labor Relations Act to provide that employers can pay an employee in bargaining units greater wages, pay, or other compensation by reason of his or her services as employee than provided for in a collective bargaining agreement. That means you can show extra benefits to folks in the union. Hint, hint. It's called raise. So not a raise for employers, but for union employees. Pending regulatory action. The Department of Labor has indicated plans to propose a regulatory initiative to better implement the public disclosure objectives of the LMRDA regarding employer consultant agreements to persuade employees concerning their rights to organize and bargain collectively. This is another pro-employer, pro-union provision that is going to prevent employers from keeping unions out. It will require unions, employers, consultants, and others to file financial disclosure reports, which are publicly available. So at least you're going to see who these folks are. And advice exemption, not consultants who provide advice. The American Recovery and Investment Act of 2009, this has a lot to do with COBRA. I don't know to the degree in which y'all have been following this. There's all sorts of changes, obviously, to COBRA. They keep extending how long somebody will have an ability to participate in healthcare through COBRA. I think however the vote turns out with the healthcare, obviously this is going to affect it. But if you listen to most experts, for whatever that's worth, most of them believe unemployment is going to stay high for at least several more years. So COBRA is obviously going to be an issue, and it's very costly. Also, legislation extending COBRA subsidy for 6 months for a total of 18 months also extends qualifying events to February 28, 2010. The Department of Labor has indicated plans to propose a regulatory initiative to better implement. I'm sorry, I'm already moving on. Protecting America's Workers Act. This is going to amend OSHA to expand it to cover governmental workers as well as those in railroad and airline industries. Would also expand whistleblower protections. The Equal Employment for All Act would amend the Fair Credit Reporting Act to prohibit current or prospective employer from using a consumer or investigative consumer report for employment purposes or for making an adverse employment action. This is big. For those of you all who right now are doing credit checks on your employees to find out if they've had past problems paying their bills, this law would change that and say, if somebody could never pay their bills on time or not pay their bills at all, you can't use that as a basis for excluding them from employment. If somebody handles money for you, obviously that could be a huge problem if that's enacted.